Okay, so we've talked about wills, financial power of attorneys, and healthcare power of attorneys. Is there another common document?
There is. It's called the living will.
What is a living will?
So a living will is a document that talks only about end-of-life care. So if you should end up in the hospital, 2 or more doctors say you're in a vegetative state, you're not coming back, what does that look like, and who's making those decisions on your behalf?
So are we talking about terminating life support here?
We are, yep, talking about that.
And in a living will, I would indicate whether I want life support to be terminated, right?
Yes, it talks about whether you want it terminated and who's going to make that final decision for you.
Give me an example of what happens if I become sick and disabled and I don't have a living will.
A living will says, so a healthcare power of attorney says your healthcare power of attorney can make end-of-life choices for you. The living will, on the other hand, says you're in this vegetative state, 2 or more doctors say that you're not coming out. The living will says, can the doctor make the decision to withdraw life support? In a living will, only the doctor can make the decision.
So if I am in a tragic car accident and I am in a permanent vegetative state, like a medically induced coma, and I don't have a living will, what happens?
At that point, your family has to make the decision if they want to go to probate court to get a guardianship over you. If they don't do it, nothing can be done. The doctors can't do anything, they just have to continue to treat. Any other decisions would have to go through the probate court and the judge decides.
Okay, Jessica, on the topic of end-of-life decisions and someone in a permanent vegetative state, is there some overlap between a healthcare power of attorney and a living will? And what are the differences and why would I need both of those documents?
Sure, so there is overlap. So in a healthcare power of attorney, the person you appoint gets to make those decisions for you. Unfortunately, sometimes they can't, and sometimes it's based on moral grounds or religious grounds that the person you've appointed just can't say, hey, I need to pull the plug. That's when the living will comes into place. It allows the doctor to step in and make that final end-of-life decision. Each person is different and can decide who they want to make that for them, but the living will allows somebody else to step in and help if your healthcare power of attorney can't do it for you.
So Jessica, if I have a relative who becomes ill, for example, and they don't have these documents in place, is it too late at that point?
Honestly, it depends. We recommend here you get the documents done as soon as you turn 18. You never know when life can happen. So in this scenario where your relative is older, there could be capacity issues. They could be unconscious. And at that point, you can no longer execute those documents and your only option is probate court. Again, we're back to a judge deciding end-of-life care for you or any type of care decisions for you. So that's why it's imperative to get these documents done early. Most people think, hey, I'm going off to college, I don't need them. Well, again, if you should end up in a car accident or something like that, there's nobody to step into play for you.